Firm, and today we're back for another video. And today we're going to talk about something that oftentimes is the elephant in the room when it comes to a divorce case or paternity case, and that is the issue of child support. Now, child support is very important. If you're the person who is paying child support, well, you don't want to overpay. Now, obviously, if you're the person receiving child support, you want to be receiving at least what you're entitled to and what your kids need. So, kind of to give a little background here, child support used to be based on just the payor's income, the person who was paying. It was based on their net income. Now, in 2020, the state of Arkansas entered something called Arkansas Administrative Order 10. Now, what that did was dramatically change how child support is calculated, but we as attorneys, we tend to like it because now we have a kind of a simple formula to determine what child support should be and how to calculate it. So how do we do it today? Well, it depends. First off, it's based on both parties' income now. Both mom and dad, or payor and payee. And how much you pay is totally dependent on the custodial arrangement. Is it joint custody or is it custodial, non-custodial? Is there a primary custodian versus someone with visitation? So with that in mind, the next question is, well, how do you determine the income? How do we get my number on paper of what I make, and how do we do that accurately? Well, a couple things to consider here. Number one, because it's based on gross income, what we're going to be looking at is how much do you make. Now, how much do you get paid, but how much is your gross income? And the way Admin Order 10 describes that is it's intentionally broad. Any income that you receive, whether that be from your job, even potentially regular payments from family, bonuses, maybe restricted stock that's vested, all of this will be calculated into your gross income. And the way that we get gross income typically is looking at pay stubs, looking at year-end statements, looking at something that shows on paper, here's what you made and here's what includes all of those things. Now, it can get a little bit tricky when we start talking about, well, what if you're not a W-2 employee? What if you don't get pay stubs? What if you don't get something from your employer? Maybe you operate an LLC. Maybe you own your own business. What do we do then? Well, luckily, Admin 10 Order contemplates this exact issue. And they give a set of guidelines that explains if you're a business owner or you're self-employed, here's how you're going to calculate income. And the way that they've done that is we're going to generally look at an average over a period of time, and we're going to look at what is your gross receipts minus some of your deductions. Now, something like depreciation or other deductions don't always apply. So your taxable income, or what you would put on your taxes, does not always equal your income for child support purposes. So if you're self-employed, the Admin 10 Order says specifically it can be difficult, and so that gives attorneys some leeway and some room to argue what deduction applies, what doesn't. But luckily, the Admin 10 Order gives us a great guideline to determine what should be included and what should not. Now, the next thing to consider is, I represent one client, and then there's one on the other side. How do we make sure both incomes are accurate? How do we make sure that my income is accurate, but also the other party? It may come as no secret, but a lot of times people say, they're making more money than that, or they're hiding cash under the mattress, or we have to figure out where all this money is being hidden because I don't want to overpay. And that's totally fair and frankly a rational thing to consider. So we do a process called discovery. We can request documents, bank information, they have to fill out affidavits, and they have to answer questions under oath that they're going to be accountable to in a court of law that says, here's the income that I make, here's how I got it, and here's the paper trail explaining some of it. And so discovery for us is a process that really helps us lock in the other party to make sure that the disclosures and the income that they're making is accurate. And then on our end, we can shore up the paper trail on our side to make sure what we're disclosing is accurate. So everyone is on the same page in terms of getting an accurate and a fair number for child support. So as we continue down our child support checklist, number one, we know how many children we have. That number is going to dramatically affect the amount of support. Number two, we know what the gross income is for both parties. We've done the discovery, we've got the affidavits, we've got those numbers lined out. And number three, we know what the custodial arrangement is going to be, whether it's joint custody and one party is paying an offset, because even in joint custody, one party can still pay support if they make more than the other, or it's custodial, non-custodial, meaning one parent has visitation and one's primary custodian. And now the last thing to consider to make sure support is accurate is additional deductions for either party, which are right there on the worksheet. So let's go through some of those. The first one is going to be child support that you're paying to somebody else. Maybe you had a previous relationship and maybe you're paying child support to another party. That's going to be deducted off of your gross income. The second is going to be childcare cost. Most people today, they have childcare cost, and We all know childcare is not cheap. So if you're going to be paying a lot for childcare, let's go ahead and get that deduction on your child support, and that's going to be factored in on a percentage basis. The next is going to be extraordinary medical expenses. Does your child have any special needs? Are there medical expenses that are extraordinary? And the term extraordinary is defined by Admin Order 10 to see if that deduction will qualify. And the last is going to be spousal support paid. In a previous case, or in that case, does spousal support, is it being paid, and can that be deducted off of your income? So if we go through all of these deductions, and we've got the numbers, we've done the discovery, we know what you make, we want to make sure we do that last step. We want to make sure that you get those deductions, because it can be meaningful. If you're paying $5, $6, $7, even $1,000 a month in childcare, you want to make sure you're getting that credit, because if you're paying that on the front end for your child, you should be receiving it on the back end in terms of child support, especially if you're paying all of it. Maybe the other party isn't. So now that we've kind of gone over how do we get to a child support number, how do we determine what one party owes the other, I want to talk about some of the most common questions that we face that can kind of give us fits, that can kind of throw a wrench in our plan to say, we're going to do some discovery and figure out the perfect numbers and get it all cleaned up. It doesn't always happen that way, as you may imagine. And the first issue we run into a lot of times is when someone is arguably underemployed. Maybe they were working somewhere, they were making a good income, and all of a sudden they decided, I don't want to work anymore, or maybe I got fired, or maybe I had an injury that made me leave my job. Now, depending on the facts and circumstances, the argument for someone being underemployed is something that you can make. And one party can be imputed the ability to make more income than they're actually receiving, and all of those factors are laid out in Admin Order 10. We won't go through all of them today, but those arguments can be made. Now, the second scenario that sometimes gives us fits is when one party isn't working at all. And so the question we often receive is, I don't have any income. Is my income for child support automatically zero? Well, the answer to that question is usually no, actually. The Admin Order 10 presumes that if you're an able-bodied person, there's a rebuttable presumption, meaning that it's presumed by law that you're capable of earning at least minimum wage or capable of earning income. So if a party comes to us or a client comes to us and they say, I'm not working, maybe I stay home with the kids, my other spouse works, my income is zero, right? Well, like I said, usually not. And most of the time, if they're an able-bodied person, they're going to be imputed at least minimum wage, which is, again, around that $1,907 number. Now, another common question that we get is, I've talked to my spouse and we've agreed that child support is going to be X dollars a month. Let's say we've agreed that child support is going to be $300 a month. Well, we put the incomes in and we do all the numbers and all the deductions, and maybe it's much more or much less than that. Are we allowed to agree to just a set number? The answer to that question is usually yes, but it's going to depend. What the admin order says is that the child support, that's the presumptively accurate amount. And so the court, the judge is able to deviate from that number, because ultimately the judge has to approve it. You can deviate from that number, but there has to be listed reasons in the decree to deviate. So a common example would be something like the child support worksheet, all the numbers say it should be $400, however we want to agree to $250, and in consideration of agreeing to $250, the party who is supposed to pay more is going to pay for gas to exchanges and school supplies. Something like that as a general example. So attorneys can get creative in terms of contracting or negotiating the amount of support, even if it's typically set on the chart, but it's very important to know that there are pretty strict rules in order to do that, which require a little bit of nuance and understanding of Admin Order 10. Now, another question we get asked is, let's say you're a dad and you just found out that you have a child, the child's 15 years old, congratulations. However, now the question becomes, am I going to owe 15 years of back child support? Well, thankfully in Arkansas, the law has recently changed, and it's limited that to 3 years. And so you're not on the hook for 15 years, but you may be on the hook for 3. Now, even within that 3, there are other factors to consider, such as, did you all ever live together? Did you provide any support during the time? Were there any other payments that were made that maybe you could get credit for? Those are all facts to be determined, but at least if your question is, am I on the hook for 10, 15, 18 years of support? Typically that answer is no. Okay, so we're continuing on this child support journey, and now the question is, who do I pay support to? How do I make sure the party gets paid? Well, there's the Office of Child Support Enforcement, which most of the time on a final order, payments are made through their office. Now, I always prefer to do it this way because it's good record keeping. What you don't want is to have a couple Venmo payments here, maybe a Cash App here, and then there's a dispute. Did those payments get made or not? Were they from you? Were they not? It can just get a little bit messy. It's always cleaner that typically how we handle is pay through the Office of Child Support Enforcement. They have a great record keeping as far as making sure the payments that you've paid or received are accounted for, and that kind of everyone is on the same page as what is the obligation, what has been paid, and potentially what is owed. Now the positive side is we know how much support is owed and we know how much is paid. But the other side of that is, OCSC, if they keep good records, they want to be paid. And depending on what type of case it is, whether the OCSC is a party to the case or whether you just have an administrative case with them, is going to dictate what role they play in terms of enforcing that support obligation or even opening a case against the payor to make sure that they get paid and that the party to receive payment also gets paid. Now, we're not going to go into OCSC and all the ramifications, but it's very important to know that when you have a final order of support, not paying support is not something to mess around with. It's not taken lightly in the eyes of the state or the eyes of the courts. And so if there's a support order, we always encourage to stay up to date on your payments. If there's issues with your payments, that leads us perfectly to a next segue, which is what do I do if my income changes? Am I stuck with this amount forever? I was ordered to pay $400 at my job, but I don't make that same amount anymore. My income has now changed. What do I do? Well, the statute specifies a change in income, a material change in circumstances similar to change in custody, but a material change for support is 20% of your income downward or the other party's income upward. It's either party's income. Now, the case law also specifies that there are other circumstances and factors that can allow support to be changed under the 20%, but the 20% is kind of the gold standard. So just because you've gone all the way through this process, you got an order, we figured out support and you're paying it, you're not stuck to that amount forever. But if there's a change in your income, there's a change in your circumstances, or you believe there's a change in the other party's income, it's always a good idea to seek counsel to determine, do I have a case for modification of this support obligation? Do I not? And what do I need to do if, frankly, I'm having a hard time affording the support that I was previously ordered? So really, no matter which circumstance that you're in that we've discussed, maybe it's a new case and we're trying to figure out what is support going to be long term. Maybe it's a paternity case and you've gotten some visitation rights, or the other party was given visitation rights, and now you got to figure out child support. Or maybe it's a case that's been reopened and your former spouse and or the state is coming after you saying you owe more or you haven't paid what you're entitled to pay. Really, any of those circumstances or others, we have a lot of experience dealing with exactly those types of facts and kind of handle each of those situations. There's a lot of nuance in determining support, and it's dependent on kind of which of those buckets you fall into. Thankfully, like I said, it's something we deal with almost every day. It's something that we're confident in handling, and we can help you regardless of where you find yourself. That's very rewarding at the end of the case to look at it and say, we started with all these open questions, and now we've got a lot of answers of what support is going to be paid, how am I going to make sure that I'm not overpaying or that I'm receiving what I'm owed, and frankly, to make sure that my kids are going to have the money that they need to get the necessities that they need to be taken care of. Well, thanks for watching today's video. I hope you had questions about child support, how we calculate the income, or some of the miscellaneous questions we went over. It was helpful. If you have any other questions, feel free to give us a call, maybe shoot us a comment, and we can try to help you answer those questions. And better yet, if you have a case or you're in the middle of something that you're dealing with, we have a free consultation. We can sit down, we can walk you through which category do we think that we're in, how do we think we can assist you in getting child support calculated, getting calculated accurately, and making sure that you're protected and that your family's protected.